Hello everyone, this is Sonette Magnus and I'm presenting here today with John Kingston, and thank you for attending today's 2022 Business Litigation webinar series, Nuts and Bolts of Attorney-Client Privilege, what it is, when it applies, and when it may be worth waiving. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. This webinar is CLE accredited for California, Illinois, and Texas for 1.0 hours of ethics credit. Missouri is approved for 1.2 hours of ethics credit, and New York, transitional and non-transitional, for 1.0 hours of areas of professional practice. We award CLE based on attendance for the entire 60 minutes. During the changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we will display secret words in 2 multiple-choice polls during the webinar. You will be required to select today's secret word from a multiple-choice list. Please respond to these 2 polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in the course. Thank you. John, over to you. John, if you're speaking, just check if you're on mute.
I wasn't on mute. Using, I guess, a phone problem. Is this any better?
Yes, we can hear you. Thanks.
Try this one more time. How about that?
Yep, we can hear you.
Very good. Sorry about the technical difficulties, everybody. As I was saying, I think this is going to be essentially a 2-part presentation. I'm going to talk a little bit about the basics of the corporate client privilege and talk about a few pitfalls and best practices. And then Sonette is going to talk about some of the practical issues that we face in this area and talk about a pretty, in my view, a fascinating decision that has recently come down related to the inquiry surrounding the January 6 events and John Eastman. Before I start, I think it might be useful for me to just kind of direct everybody to a couple of resources at the end of the packet that is appended to the webinar page. On page 37, there are some checklists that we think might be useful for kind of evaluating the privilege on your own. And then on page 42, there are some useful resources that I've relied on in kind of making a privilege evaluation that I would recommend to those of you who are interested in kind of doing a little homework on your end. I wanted to make sure that I remembered to point those out to everybody, and if I don't do it now, I'm probably not going to do it. So let's jump right in. Obviously, there's a wide variety of ways in which courts have articulated the basic privilege test, but the basic privilege, the basic attorney-client privilege has 4 parts. You need to have a communication between the lawyer and a client. It needs to be for securing legal advice. It needs to be both made and kept in confidence, and the privilege must not have been waived. Right off the bat, I want to devote a slide to some of the very, very common misconceptions. I would say, this is not a scientific estimate, but in my view, kind of 70%, 80% of the problems that we see with respect to folks trying to invoke the attorney-client privilege without success come down to very basic mistakes. And these are basic mistakes that are made frequently by lay people, but also occasionally by lawyers. So if you can get these right, my view of the world is that you're getting rid of 70% of your problems. You need to remember the privilege does not protect underlying facts. You need to be aware that it doesn't protect non-legal advice. And this one happens more often than you would think, but you need to remember that the privilege does not apply retroactively. I can't tell you how many production fights we've had related to some sort of unhelpful correspondence or communications or discussion where somebody tried to retroactively make that a secret discussion by looping in counsel. That is not a thing that works very often, and at least in my experience. So those are basic privilege misconceptions. Those are not unique to the corporate client privilege, but those are some that can trip you up, regardless of whether you're trying to assert a privilege on behalf of an individual or a company. Corporate client complications, in my view, can be broken down into three basic categories: who speaks for the client, what role is the lawyer serving, and then what communications are being kept confidential. There are just a host of jurisdictions that apply different tests, and privilege decisions are notoriously fact-specific and policy-driven, so it's really not possible to give a concrete analysis that you can use in every stage, in every circumstance, and the best that I think you can do is to try and develop some general heuristics and then do some homework on your end specific to your jurisdiction and circumstances as the need comes up. Who is the client? The client is the company, it's not its agents. This is frequently misunderstood, and that misunderstanding has led to bad results both for the lawyers involved sometimes and for the company and for the company's agents. This is something that Elizabeth Holmes ran to in her trial, or in the lead up to her trial in 2022, where she attempted to invoke a privilege for communications with David Boise, and the court found that no, Mr. Boise was acting as Theranos' lawyer, and those were not, there wasn't a privilege that Ms. Holmes was able to control. In 2020, Penn State's general counsel ran into trouble on this end as well, where administrators claimed to mistakenly believe that a university lawyer was acting as their own lawyer. The Penn State example, I think, is particularly troubling because Penn State did it right. They issued an Upjohn warning, which we're going to discuss later, and made the administrators, or attempted to make the administrators aware of the fact that the lawyers were lawyers for the company and not for the individuals. But nevertheless, the individuals in my view, had an incentive to claim confusion where maybe there really wasn't confusion in an effort to avoid certain charges. So in dealing with who is the client question, I do think that it's important for counsel to be aware of the perverse incentives that some individual agents of the company have to claim they're confused when in fact they may not be. Generally, the corporate client is going to be somebody who has to decide, who can provide relevant information, who has to follow the lawyer's instructions, or can assist in the litigation. The rule of thumb that I would suggest is before anybody is treated as the corporate client, that is somebody who can speak or listen for the corporation, you should have a good reason in your mind why they're being included in the communication. We need to learn something from this person. We need to tell this person to do something in order to carry out legal advice, or this person needs to make a decision on behalf of the company. I'm including this choice of law slide not because I want to spend a lot of time talking about choice of law, but because this is an area that is frequently overlooked, and it's an area that I would encourage our in-house friends and my partners listening on this call to consider more frequently than not. If you just make a note on your notepad that says choice of law and you think about choice of law before you file a lawsuit or start an investigation, this slide has done its work, and I'll move on. The predominant test throughout the jurisdictions is the Upjohn test based on a 1981 Supreme Court decision. That's applicable in federal courts and in many state courts. And again, the focus is, was there a good reason to be including these employees in these communications? And the factors that are considered in that respect are all sort of consistent with that broader theme. I mentioned an Upjohn warning earlier in the presentation, and an Upjohn warning is sort of a jargon term for a disclosure that is made to the agents of a company to make sure that there is no misunderstanding as to who the lawyer represents and to whom the lawyer's duties flow. So it serves two purposes. It protects the corporate privilege, and it avoids ethical difficulties for in-house counsel in the variety of checklists that I've referenced at the back of the packet. We do have an exemplar Upjohn warning that sort of tracks what you see before you on this slide. The key is that essentially you are having to talk to lawyers for a reason. We think that as the employee, you may have relevant information. The company is the client, and you can get your own lawyer if you would like. There needs to be an emphasis on protecting the confidences of the company, and there needs to be a disclosure that the privilege belongs to the company. It doesn't belong to the agent or the employee with whom you're talking. It's really important that the agent doesn't think that he or she can instruct you not to disclose something if you're representing the company. That's a company decision. I want to talk a little bit about some best practices. Right off the top, I try and make it a privilege explanation. A lot of folks call it an Upjohn warning. I try not to do that because it sounds an awful lot like a Miranda warning, and it's Mirandizing company employees, and in my experience, is not a great way to start a productive conversation. So to avoid, frankly, scaring your employees, it would be nice if you didn't call it an Upjohn warning. I would also make it a habit. My experience is that we're pretty good about remembering to give an Upjohn explanation when there looks to be some criminal exposure, when there looks to be a pretty serious situation. But if you give the Upjohn explanation as a matter of course, even when there doesn't seem to be any real possibility of an employee developing a conflict with the company, then you're not raising red flags just by giving the Upjohn explanation when you do. I think it would be useful to conduct regular privilege training, and that privilege training should include an Upjohn explanation, and it should be memorialized. Annually, it wouldn't be a bad idea to put together a little PowerPoint for the decision makers to kind of walk through the privilege with them, and in that PowerPoint, it would be nice to have some form of an Upjohn explanation that you would then be able to use if, heaven forbid, there was a dispute that comes up down the road. And along these same lines, I think it would be useful to consider an Upjohn explanation in the litigation hold notices that you send out. If you're going to be communicating with employees, telling them to hold on to documents and ESI, I think it's also a good idea to explain to them and memorialize the explanation of the potential for conflict, the importance of keeping things in confidence, and who controls the privilege. In-house counsel frequently serves multiple roles. I think that in practice, the privilege assertions that are related to outside counsel are scrutinized less than privilege assertions related to in-house counsel. That is not something that is recognized in law, but I think that in practice, special masters and judges tend to view the world that if you've retained outside counsel, that the communications with that outside counsel are likely privileged. I don't think you get the same benefit of the doubt when it's in-house counsel. So there is de facto heightened scrutiny in my view. Best practices if you're serving a dual role. I think it makes sense to segregate your legal and non-legal files. You should document that when you're acting in a legal capacity that there is a law-related reason for that consultation, and you should, in your communications, you should be offering advice. You should not just be simply reporting or reciting facts. That raises the question, what is legal advice? It needs to be advice that is to secure a legal opinion. Is this something that we can do given the regulatory environment in which we operate to provide legal services? Can you look at this contract? Or to assist in a legal proceeding, we've been sued, we've got an arbitration coming, and we need your help. The advice should be related to those topics generally to constitute legal advice. Mixed legal and business communications are generally protected. So if there's some advice related to a deal, we may want to think twice about buying this company because of related litigation that we would be inheriting if we did. That would be a communication that would generally be protected, but pure business communications are not. I think it might be useful to kind of just to walk through an example of an electronic mail chain and talk about some of the concepts that I've been discussing. This is an email chain related to a hypothetical circumstances involving I guess a verbal outburst at a Harbor Valley operations facility. So there's a correspondence from the vice president of the operating group to the operating group. Includes an Upjohn warning. Hopefully they call it an Upjohn explanation, but letting all the employees know who the privilege belongs to, that they can get their own lawyers, and that they need to keep things in confidence. I like, when it comes to the subject headings of internal correspondence, I like using confidential legal advice and do not forward more than I do attorney-client privilege headers. I think the problem with just general attorney-client privilege headers is that if it's something that you automatically plug into your emails, then it's really not reflecting an informed decision as to whether that particular email is privileged, and it's not going to be given much deference. And if you don't plug it in automatically, then you're going to forget sometimes, and there's going to be the problem of you didn't put attorney-client privilege header, you didn't put a header claiming privilege on this email when you put it on other ones, and therefore there should be some negative inference. So I think the better practice is to use that real estate in the subject line to protect confidences and to advise the recipients not to forward the correspondence. You can see here that the correspondence was forwarded along. It looks like it was done at the request of counsel, so it doesn't look like this forward should defeat the privilege, but it would still be preferable for the counsel or the lawyer to forward the communication. Then if you have an unauthorized forward, well, that means that communication is likely not privileged itself because the confidence was broken as to that communication, but I think you would still have a pretty good argument for defeating a waiver claim because the forwarding employee didn't have the authority to waive the company's privilege, and the company had taken steps, including multiple warnings, not to forward the email. So it has a pretty good argument that it's taken reasonable steps to protect its privilege. That's a summary of what we've just discussed all in one slide. I think some best practices that are worth talking about for electronic mail are, again, in-house counsel should be the sender. It should be very clear from the contents of the message that this is a legal communication, so you're providing legal advice or you're doing an investigation to address a legal concern. The message should state that it's confidential and instruct the recipient to maintain confidentiality. And there should be an explanation as to why or the recipients of the email are on the distribution list. You've been chosen because we think you might have information related to A, B, or C. I think it's a useful thing to handle. Looks like there is a question. What if you are a licensed attorney working for a company, but you are not counsel for the company? An employee shares something with you that could lead to legal action, and that employee knows you are an attorney. Does the privilege attach to the employee? I think in that circumstance, the privilege analysis would, I think there's two parts of the analysis. You're working for the company, so I lost the last part of that email. I think if you were working for the company, the privilege would be the employees sharing with you would, in my view, not be a privileged communication that well, let me think this through. I'm sorry, I lost the connection on this and I can't see the question.
So I'll read it again for you, John. This is Sonette.
Thank you.
What if you are a licensed attorney working for a company, but you are not counsel for the company? If an employee shares something with you that could lead to legal action, and that employee knows that you're an attorney, does that privilege attach to the employee?
Okay, so I think that the way that I would answer that is if you're outside counsel working for a company, then you can assert a valid privilege on behalf of the company. I think that the question leads to kind of that first or second slide that I raised, which is if the employee shares a fact with you that could lead to legal action, well, that fact isn't going to be the existence of that fact is not going to be a privileged thing. There's not a privilege that attaches to that fact that you could conceal it. You relaying that communications to the company, you could claim privilege for that, and whether I think you could have a fair argument, depending on the test that applies, that your communications with the employee itself are also privileged. But that underlying fact, the something that could lead to legal action, that's not going to be a thing that the privilege can protect. And I apologize for taking so long to get through that email. It kept falling off my screen.
Yeah, it's tricky. And I would just say that to the extent the question means that you happen to be an employee of the company and you happen to have a law license, but the scope of your job at that company is not one of being an attorney. So I think that's a reasonable interpretation of your question as well. I would flip that and say, since the scope of your job for the company does not involve you practicing law in any way, shape, or form, you just happen to have a law license, then that communication would not be privileged, because there would be no reason for the employee that shared the information with you to assume that you were acting in the scope of an attorney for the company, since I would imagine your title is one that makes it clear that you're not an attorney for the company. If that ever happens, I would advise anybody that happens to have a law license but has been put in that position to make it clear to that employee, hey, by the way, you know that I don't work as a lawyer here. Maybe you should talk to, X, Y, or Z about that. Just to the extent that that's what you meant by your question, I would just add that caveat.
I think that's the better reading of the question. I think that's exactly right.
There's a second question, John, and it is, can you avoid a breach of the privileged communication if you avoid using do not forward?
I'm not sure that I follow the question, but I would say that I don't think that do not forward, putting do not forward doesn't guarantee that the confidentiality can't be broken, and doesn't guarantee that a reviewing court might not find that you didn't take reasonable steps to protect confidentiality. So it's a practice that I think might be useful. It's certainly not a necessary condition to protecting confidentiality.
Correct. I think in that instance, it's very important that we have good policies, procedures, and communication with the employee base on who should be included on emails in the first place. So you can't forward something that you don't have. So to the extent that there's the subject matter of the communication includes privileged or confidential information, we need to be very careful and mindful of who's included, that we have the right tier or level of employee within the organization included on that communication, so as to avoid having somebody breaking privilege that really should have, A, never been privy to that information in the first place, or two, forwarding it to somebody that that communication or document to somebody that it should not be forwarded to. I think there's one other Part B question, John, for you, and it is regarding the question just asked. If you're in the compliance department and not in the legal department, but the rest of the facts are the same, as in the employee knows that you're a lawyer, they know that you're in the compliance department, but that you're not employed as counsel for the company, does privilege still exist? So I read that question, or I understand that question to be, can a compliance officer whose scope of employment is that of a compliance officer, not as counsel of the company, is that individual able to have attorney-client privilege on behalf of the company? I think that was 10.
Yeah, and I think if you're not acting as a lawyer, I would not count on being able to invoke any attorney-client privilege. So if your role is not that of providing legal advice or assisting in a legal proceeding, then I would not bank on being able to assert the attorney-client privilege. We see this a lot with in the paralegal context as well.
Yes, and as a subpart of that question, I don't think, and John, leave it to you to comment as well, I don't think it's necessary that attorneys who were once licensed that take technically non-legal or legal adjacent roles to go inactive with their bars. I think it's more important that we make clear and define the scope of their employment with their current organizations, so that it is known and they regularly reinforce whether they are or are not an attorney acting for the corporation. Specifically, the question was whether John and I would recommend lawyers employed in non-legal capacities go inactive with their bars. I don't know if you have another thought on that.
No, I think that exactly as I would. I think that's exactly right.
Okay, back to the presentation.
So I think that it's time for me to do the first secret word. Today's first secret word is banana.
Okay, I'm just going to wait for a couple more people to submit. Again, the secret word is banana. Please pick the correct word below in the multiple choice that should have popped up on your screen. Waiting for just a couple more people. Okay, submissions have slowed, so once again, the secret word is banana.
I am resisting an urge to spell it.
Okay. Well, thank you, John, for providing us with those fundamentals on attorney-client privilege. So as a recap, John discussed, Upjohn warnings, his position on that, and the attorney-client privilege, what it is and isn't privileged, some common misconceptions, the distinction when we have an attorney that's also acting as corporate secretary, and some best practices, and challenges when there's a corporate client. and who has the privilege, whether the principals or the agents of the company and the company have it. And of course, how to protect confidentiality. In this portion of the presentation, we're going to discuss some practical considerations on the application of the attorney-client privilege and when it may become crucial in your practice or for your organization. Let's see here. So as our practices evolve, so too do some of the rules and regulations that our clients and organizations face. Many of us have counseled our companies and clients that regularly encounter some regulatory issues or face reporting requirements to state and federal agencies on how and what should be reported, when, and why. Some of our clients have faced, for example, grand jury subpoenas or ordinary subpoenas, indictments, or have later entered into corporate integrity agreements and settlements of investigations that can arise out of a variety of false claim statutes and the like. And so we see this in healthcare, in our mining industries, education, some import-export industries, and just to name a few. Most of the agreements or regulatory exchanges have come to either require or expect some kind of pre-existing voluntary compliance program that will have a compliance officer or someone that oversees the policy or program with independent review, some developed written standards, policies and procedures, and a comprehensive employee training program on the existence of that program and policy and how to use it, as well as a confidential disclosure mechanism, some kind of like a hotline or the like. And sometimes the self-reporting of any violations of laws or regulations or failure to comply with certain obligations are mandatory, especially for some of you who may have a client or your company acts as a federal contractor, and they may have received like an overpayment from the government, for example. While having a formal internal investigation policy and procedures now kind of commonplace, if you will, some are starting to face two primary instances where the attorney-client privilege becomes a bit of a thorny issue. That is, first, when there's a challenge that because the internal investigation is being performed pursuant to an internal policy or procedure, then the internal investigation itself is a business record, not a privileged communication seeking legal advice from an attorney. And as such, the attorney-client privilege would not attach. So it's typical that in internal investigations of all sorts, whether related to an employment issue or to a regulatory compliance issue, that such be conducted at the direction of an attorney. This, however, is not always the case and could lead to further support for the position that the records of the investigation are discoverable business records. So the most straightforward way to create support to defeat those types of challenges down the line are to analyze the corporate policy and procedure of your company or your clients to make sure that there's a statement that the internal investigation is performed for, among other reasons, the corporation to get legal advice. The second way, and in a way it's kind of the most known or best known or well-received way to defeat this business record challenge is to ensure that the investigation is being conducted by or at the direction of counsel. So that is, the attorney should be involved in determining, for example, the interviewees and designing the questions for the interviews and orchestrating where and what to search for the information, the search terms if we're looking for ESI, and the like. It may not be practical for all of the investigation to be conducted by an attorney, in which case it's just most important that we're clear about the paper trail connected by the agents that are doing the investigating, the searching, or some of the interviews in some instances, to make it clear on its face that the investigation is being conducted by or at the direction of an attorney. The third, and just as important as kind of steps 1 and 2, the third way to give yourself the best chance of defeating these business record challenges, to ensure that the investigation be heavily documented. There should be a clear line between the documents created by the attorney and the agents or the staff persons that assist. So for example, you may have employees submit something in draft for the attorney's final review and QC it, and so that way we can make sure that the words chosen are legal in nature. And we heard John speak a little bit about some do's and don'ts and trying to make sure that we use language that sounds like legal advice is being sought. In the documentation, and as well as in the interviews and in the instructions to staff that will assist in the investigation, it should be made clear that the investigation is confidential in nature, and that is essential. It's essential to the investigation that the content, the design, every component of the investigation remain confidential. Likewise, when possible, emails and other communications should be designated accordingly, whether it's confidential or attorney-client privilege. And we've had some discussion on that today, or that's not always a full proof. Just because you put attorney-client privilege on it doesn't mean it's privilege. We still want to make sure that we're paying attention to the substance of the communication, that it's advice-seeking or has a legal intention in the communication. It's become very important that if your client faces some civil or criminal litigation or a subpoena, including grand jury subpoenas, that compliance programs become an expectation that certain organization has. That is that, sorry, I lost my place. That is that the government's going to start to expect, especially when dealing with the Department of Justice, and in considering the principles of federal prosecution of business organizations, which you can find on the Department of Justice website. Assistant USAs will take a look at the principles of federal prosecution and expect that your organization have compliance programs. Attorney-client privilege is often a thorny issue because on the one hand, the corporation may want to earn leniency with the DOJ, and these considerations may include voluntarily disclosing some information, and some information may be included in what could be deemed a privileged communication. But on the other hand, the principles make it clear that waiver of attorney-client privilege is not required. So in these instances, the focus has to be on whether or not there is a way as the attorney to find a way to share with the regulatory body or with the government the facts surrounding whatever the investigation is surrounding without waiving privilege. So that's really where legal talent is really put to the test, and it becomes crucial to assess the documents and find those that have legal opinion contained within the document so that we keep those privileged, and then figuring out how to best ensure that the facts are conveyed without waiving privilege. And this is very important to find this line because, waiving attorney-client privilege, more times than not, is a bell that simply can't be unrung. I see a question here. Give me one second. The question is, don't John and I think it's important to have a senior decision maker of the client document his or her request to counsel for legal advice concerning, XYZ, and ask counsel to undertake direct an investigation of the facts necessary to provide that advice? So it depends on the structure of the organization. So, for example, sometimes the advice sought comes in through, for example, a hotline. And so there might be a compliance officer that monitors the hotline, and then when the internal policy procedure, when something comes in, depending on what the issue is, it may be funneled to A, B, or C. It may also be an internal procedure that once, A, call them, legal counsel, gets that, then it's their job to also bring in whoever it is that they directly report. So, for example, the senior decision maker in this instance may be either general counsel or assistant general counsel. So usually built in or baked into the compliance program is the inclusion of a senior decision maker of the client. And I think that that's probably the key component that you're trying to get to, which is that we don't want to have rogue employees doing or rogue attorneys for the company doing an investigation without anybody in senior leadership becoming aware. It would be baked in that or implicit in this instance that the investigation that's being conducted would be in order to advise the client on how to take the best legally compliant action depending on the results of the investigation. John, do you have anything to add there?
No, I think that covers it. I think that I think it would be important and very helpful to have a senior decision maker document the request. Whether that's if there's something directly from the decision maker or counsel just makes the record that the decision maker has asked us to look at thus and such for thus and such reason. But yeah, I think it's something worth pointing out. Yeah, it's a very important.
Sure.
It's a long way of saying I agree.
The other thing I want to bring to everyone's attention and discuss is the concept of selective waiver. And that is, selective waiver is the idea that certain privileged documents on the same subject matter could be produced while others withheld. And I generally just advise against this and think it's just a terrible idea because of how the courts have handled instances of selective waiver. So I've seen some attorneys try to parse the line by date, saying that, for example, privileged communications on a certain subject matter before X date could be produced because they're inconsequential, but between, Y and Z date, they want to withhold those as privileged. And those types of determinations have been heavily scrutinized by the courts. So I heavily advise against them. Likewise, within the same subject matter, I've seen some instances where the decision to investigate and the privileged communications are being are willing to produce those. They're willing to produce the design of the investigation, but they don't want to produce the results of the investigation, but they will produce the corrective action or something along those lines. Again, selective waiver has been heavily scrutinized and rejected. The public policy, argument being that since Congress has declined to enact a privilege to protect disclosures to the government, assuming in this instance that let me back up for a second. The third way that I've seen selective waiver applied, which has been almost universally rejected, is where a company may wish to cooperate with the government and produce privileged documents to the government, but then later face civil litigation and wish to reassert attorney-client privilege in that instance. And so in all instances of selective waiver, we heavily advise against it because, kind of like what I said before, attorney-client privilege is just one of those things that when that bell is rung, we cannot unring it. But more importantly, the courts have not supported these types of splitting hairs. At times, you'll have a confidentiality agreement with the government prior to disclosure, but even in that instance, I've seen some courts later determine that even with the confidentiality agreement, sometimes documents that were produced that were privileged went a little bit beyond the scope of that agreement. Therefore, waiver, the confidentiality agreement didn't apply to those documents, and since those documents are part of the same subject matter of other documents, privilege is waived as to the whole. So it's probably best just to avoid the entire potential for waiver. I wanted to take a few moments to discuss privilege logs and how to of course, the best way to assert your privilege and to document it is to have a privilege log. And I won't spend too much time here, but I just want to remind everyone to ensure that the entire subject matter of a topic remain privileged for the reasons just discussed. And we want to be careful and pay attention to the categories reported on the log. In following Federal Rule of Civil Procedure 26B5, we have the outline of that, or the support rather, that documents can be withheld. But we don't really have an outline of what needs to be disclosed about what's being withheld. So as a practice point, I recommend that we pay close attention to ensure that just the date, document type, email, to, from, CC, blind copies as well, a description of the document, and your privilege justification be what's disclosed on a privilege log. And I mention this because, back in the days of yore when I started practicing, I did my privilege logs on a Word document or an Excel spreadsheet, and so all this information was being manually typed. Obviously today, things have progressed, and we're using our online review platform to do this. When documents are uploaded, the metadata follows, and that could include a lot of additional information that is possible to export on a privilege log when created on, Relativity or another online platform. So I'm really just advising here to just pay attention that that type of information is being removed, and to the extent that you do an export to an Excel spreadsheet from Relativity, it's not enough just to delete the column. You have to wipe the metadata in that document as well to make sure it can't be undone by when you send off the privilege log. So that is some of the types of information that may be included if you don't manually remove it and then wipe the document. Might include the custodian of the document, where the document was found within the company's internal server, the size of the document, and of course the obvious thing to remove, because it may reveal privileged information as the subject line of an email. Different attorneys practice differently, but I recommend keeping the family of documents together, and this is my practice even though an attachment may not contain privileged information, but it helps to avoid a lot of gaps in the privilege log and the creation of questions and making discovery even more expensive than it already is. I advised using, or most people are going to use, an online platform to maintain or create their privilege log, and I gave some ideas on things to be careful in the export. I also want to remind people that there's no need to manually today, or there may not be, depending on your jurisdiction, to create customized document descriptions. It's possible just to create a second review platform where you have categorical descriptions of the documents, and that can help creating your privilege log even faster. Another thing that's gaining some steam in practice across all the states are categorical privilege logs. I have recently done this without issue in one of my cases, and that is where you have a one-page privilege log where you are essentially reporting how many of a particular type of category of document is being withheld. And so I created a model categorical privilege log here just to give you an idea of what it could look like, and say, okay, here in this first example, communications with outside counsel, we're withholding 22 of those documents on account of attorney-client privilege. Or communications with non-lawyers containing information prepared by or on behalf or at the direction of an attorney, we're withholding 44 of those documents, and we're claiming attorney-client privilege and work product. So there's something to think about as we all try to find ways to keep things moving along. I wanted to spend.
It looks like, I'm sorry, Sonette. Two things. There's a no sound question that's come through, and then we're getting scolded. Identify the second secret word.
Yeah, I see the time. Dora Elba will handle the no sound. So in our remaining time, I wanted to briefly discuss one of the most interesting attorney-client privilege cases. I guess that have recently come down, and that is Judge Carter's consideration of primarily 9 communications, what I'm going to talk about, but there were 111 total, where Professor Eastman at Chapman University, who had claimed to be counsel to President Trump during the last election, as well as during the before and after time period of the January 6th insurrection. So let's see, we have the House of Representatives Select Committee investigating the January 6th attack on the U.S. Capitol. They essentially wanted to obtain emails sent or received by Dr. Eastman on his Chapman University email account between November 3rd, 2020, Election Day, and January 20th, 2021, following the insurrection. The court had limited the scope to January 4th to January 7th, given the key date here being January 6th. Dr. Eastman claimed privilege on some of those emails. The Select Committee objected and asked the court to review and to rule on certain emails. They had oral argument March 8th, and then we got the opinion later that in March. So what the Select Committee decided to do was issue a subpoena directly to Chapman University, because at the time that Professor Eastman was claiming to be representing President Trump, he was using his university email account to communicate. Once the subpoena was issued on Chapman, Chapman University was ready, willing, and able to comply, to go into their service pool of communications and produce them to Congress. Professor Eastman filed a complaint seeking a temporary restraining order to prevent the university from complying. The TRO was granted, but a preliminary injunction was not. So the first question asked and answered by the court was, can privilege attach in this instance where we have a university professor who is advising the president and where, there was no formal signed engagement letter that you would expect, or he wasn't specifically on President Trump's staff as an attorney, but rather was an academic. And the court said, yes, it's possible, and in this instance, it's because it's clear that there was an understanding, and there's an understanding that Mr. Eastman, or Dr. Eastman, had appeared on behalf of the president and the public. He had been involved in closed-door sessions, and President Trump himself publicly acknowledged Dr. Eastman's legal role. The next question that was answered by the court here is whether or not use of the Chapman email account destroyed attorney-client privilege between Dr. Eastman and the president. And the court determined that after considering these 8 factors that are on your screen, the answer there was no. And the court relied heavily on instances of legal clinics, and sometimes professors do provide legal services for clients, pro bono or indigent clients. And so the lines between whether or not university can do that, a university can supervise email, may or may not be enough to waive privilege. You'll see that in the widgets that the actual full opinion was included. As we run low on time, I'm trying to find the second word, Elba. I cannot find it.
I think I got it.
Thank you.
So I think no problem.
So the second word here is eagle. And I apologize for running close to time, but we got all those good questions in the middle. I will just add, once again, the secret word is eagle. While you're doing that, and I'll eventually find back the slide, the court also had considered the crime fraud exception and whether or not the crime fraud exception would extinguish Professor Eastman's ability to claim attorney-client privilege over any communications. In the slide, you would see that, and it's also in the deck, that when a client the crime fraud exception thanks for whoever popped that back up, extinguishes the attorney-client privilege when a client consults an attorney for advice that will serve them in the commission of a fraud or a crime, and the communications are sufficiently related to and were made in furtherance of the crime. The burden of proof here is preponderance of the evidence, and the attorney doesn't need to know the illegal purpose of the scheme, or whether or not the scheme is successful is not outcome determinative. And the court concluded that most of the emails over which Professor Eastman wanted to assert privilege over were actually draft filings and conferrals about oral arguments on other election fraud litigation throughout the country, so they didn't really further the January 6th insurrection, but there was at least one communication that, in the court's opinion, did, and therefore the judge ruled that for that particular communication, crime fraud exception extinguished privilege. Ultimately, the court concluded that Dr. Eastman did not meet his burden to show that the communications were privileged, and that in most of them, neither President Trump was a sender or a recipient of the emails, and they were sent by third parties, where somebody that is somewhat related to the president may have been blind copied, but that was it. So in the interest of time, if you have more interest in this order and the thorny attorney-client privilege issues presented, it is included and attached to the materials. Also, Dr. Eastman had no retainer or sworn declaration or any proof of any of the other people that were included in the emails that were blind copied were attorneys for President Trump. I'll close and just share the last few paragraphs of the judge's order, just saying that sometimes attorney-client privilege rarely implicates a situation like, an attack on the Capitol, and here the judge was looking to, give everybody some indication that there was a lot more. There were a lot of expectations on what his ruling would be with respect to these communications, but he was constrained because he only had these handful of emails to review, and the role, criminal or not, of President Trump or of Dr. Eastman here was not before him. So always mindful that judges can't always solve all problems, that they only have the power to rule on what's justiciable and what's in front of them. Again, the second word is eagle. I know that some people have complained in the chat about sound, and I apologize for that, but hopefully most of you are able to maintain a consistent sound. Internet still working itself out. If you have any additional questions from whether John's portion of the presentation or my own, please do feel free to email us and we'd be happy to answer them. And we wanted to also share a couple takeaways that you can just save and put on your desktop or in your drawer so you have them as a resource. We have a two-step analysis to help determine when privilege is attached, as well as a checklist that is included on Upjohn factors and privilege. And we also wanted to provide you with a few resources. So thank you so much for participating in our webinar. You will see shortly thereafter that we're going to have a survey that's going to display at the conclusion. Please do feel free to email John or I, and we hope you enjoyed today's presentation.
Thank you, everybody, for your time and attention. Thanks, Sonette.
Thank you. All right, bye-bye.